Hi, everybody. I'm starting a little bit early. I just want to start reviewing my book. For those of you who have already downloaded on Kindle, I have made some updates, so you probably will want to re-download it or use a live version. I think I'm not going to make any more changes to it just because I want people to actually get the paperback. So I think that what you have right now is going to be the final version. So um, you've already seen a book cover, but this book cover is relevant because it's actually broken down in chapter 6 of my book of why I made this cover. So, for those of you who are reading, you probably already, if you've already gotten to chapter 6, you know why the book cover is descriptive of the human predicament. But I'm going to start out by reading let's get to it, the epigraph. So, I have I have four quotes. Slavery implies involuntary servitude, a state of bondage, the ownership of mankind as chattel, or at least the control of the labor and services of one person for the benefit of another, and the absence of a legal right to the disposal of his own person, property, and services. Um, this is probably the most important uh, quote for my book because this basically is the basis for the disposal rights test. So that's how you that is the test of slavery. It's based on the disposal of a person, uh, his own person, property, and services, and the master state has ultimate control in every domain when it comes to this. So, because the master state has the final say when it comes to the disposal of your person, property, and services, that creates a entire framework of slavery, um, which I'm going to explain why we are slaves. That the master state owns us. That the master state has the final control over all things. So this is dispositive. For those of you who are reading the book, you probably have already gotten to this. But I go into further detail in chapter 6. So let me get to the next quote. The state has an interest in preserving and fostering the benefits that every human being may provide to the community. A community that thrives on the exchange of ideas, expressions of affection, shared memories, and humorous incidents, as well as the material contributions that its members create and support. The value to others of a person's life is far too precious to allow the individual to claim a constitutional entitlement to complete autonomy and making a decision to end that life. Now, that was Justice Stevens' concurring opinion in Washington versus Gluckberg. That is also um, a quote that I address frequently throughout this book because this is essentially telling you why the master state will not allow you to have the right to an autonomous disposal of your own person because you're far too valuable to society, right? It's not for your benefit. It's so that you can continue providing your shared memories, humorous incidents, material contributions to society. So you're being sacrificed to the collective. I want you to understand that. I'm not going to get ahead of myself because I'm going to address these chapters individually, but that was a glaring admission of why the master state will not allow you the right to opt out. Now, let's read this next one from John Jacques Rousseau. The citizen is no longer the judge of the dangers to which the law desires him to expose himself. And when the prince says to him, it is expedient for the state that you should die, he ought to die. And then my final quote is a man who retires from life does no harm to society. He only ceases to do good. This is from David Hume. Let's see if there's anybody here before I keep going. Um, I'm glad you got it. Oh gosh, I feel so bad because I made some updates and you already have the printed version. I apologize because I did make some recent edits, especially when it came to the appendix. I have appendix A, B, and C. So The substance of the book has not really been changed much, but there's some additions. If you, I do feel bad that you got the finished version. If you want, I can send you the edited version. Anyway, I'm sorry for that. I'm sorry for I couldn't think of everything, so I made some changes just recently. So thank you for your support. Thank you for getting the paperback. Um, Now, this book synthesizes four philosophical and political traditions that rarely appear together: anarchy, anti-natalism, socialism, and pro-mortalism. So these four traditions converge into this book's central argument. You were forced into existence without your consent, and you cannot exit peacefully. The state extracts from your value, from your involuntary continuation, and this arrangement is slavery. I'm not going to go the entire introduction, or this is the forward. I'm going to get to the introduction right now. All right. You did not, this is the introduction, y'all. You did not choose to exist. Your parents made that choice for you. They decided to create a person who would need to eat, sleep, work, suffer, age, and die. They imposed these burdens without your consent because obtaining your consent was impossible. You did not exist to give consent. Now you exist. You bear comprehensive costs: the cost of maintaining a body, the cost of labor, the cost of suffering, the cost of mortality, the cost of societal subordination. You will spend 28 years of your life on biological maintenance alone: sleeping, eating, hygiene, and medical care. You will work 101, 250 hours to generate income, pay 620,000 in taxes, while capitalists extract 2.7 million in surplus value from your labor. You will bear psychological, temporal, societal, and existential costs. The complete counting exceeds 5.96 million in measurable expenses, plus immeasurable suffering. What did you receive for bearing these costs? Nothing. You received nothing. Your parents benefited. They received meaning, purpose, emotional satisfaction, social status, legacy, existential validation. The state benefit. It extracts taxes, forced labor, services, obedience. Capitalist benefit. They extracted surplus value from your coerced labor. And you received the gift of existence, which is to say, you received the comprehensive cost of existence. Your parents were unjustly enriched. They obtained benefits at your expense under circumstances that make retention of those benefits unjust. This creates a debt, the moral debt for life enslavement. But this debt cannot be repaid. The harm your parents inflicted is irreparable. They cannot unimpose existence. They cannot restore the non existence you never consented to leave. They cannot give you back the years you will spend maintaining a body you never chose to inhabit, working jobs you never agreed to work, suffering harms you never consented to bear, or dying a death you never chose to face. But irreparability does not eliminate the debt, it reveals its true nature. This is not a debt that can be satisfied through compensation, paying you money and making you whole. This is a debt that requires restitution, forfeiture of benefits and rights as partial acknowledgement of uh, um, irreparable wrong. Excuse me. Your parents owe restitution. The state commits a separate breach. It prohibits you from exiting the irreparable harm your parents imposed while extracting value from your forced continuation. This arrangement has a name. It's called slavery. But no one will call it that. Your parents will say they gave you life as though imposing irreparable costs without consent were a gift. The state will say it protects your life as though preventing you from ending your involuntary existence serves your interest rather than the state's interest in continued extraction. Society will say you should be grateful as though the absence of consent and the impossibility of remedy are irrelevant details. This book calls it what it is: life slavery. This book documents how life slavery operates, who profits from it, why courts deny relief for this condition, why democracy cannot fix it, and what must be done to end it. What is life slavery? Life slavery is a systemic condition in which biological humans which I refer to as life enslavers, impose existence on a person without their consent, creating an irreparable harm and an unpayable debt, and then the master state forces that person to continue existing for the benefit of society through its prohibition on the right to opt out. Life slavery operates through systemic control and violence. The master state monopolizes disposal rights, prohibiting the life slave from escaping while extracting value from his or her captivity. Life slavery is distinguished from chattel slavery, where the master owns the person outright, and wage slavery, where economic necessity compels labor, in that it operates through control over your ability to no longer exist. You are not owned as property in the traditional sense. You are trapped in an involuntary existence, burdened with an irreparable harm and an unpayable debt, forced to generate value for the collective, which refuses to allow you to escape your enslavement while also leaving you to pay for your own captivity. Life slavery is more insidious than any forms of slavery because it operates through paternalistic deception. The claim that a forced continuation serves your interests rather than the interests of those who benefit from your captivity. The master state does not admit that it forces your continuation to extract value. Instead, it claims to protect you from yourself. The Supreme Court made this explicit in Washington versus Gluckberg, where Justice Stevens wrote that the state's interest in preserving in preventing suicide includes preserving the lives of those who can still contribute to society. The court acknowledged the state's interest, extracting continued value from your forced participation, but the court framed this extraction as benevolence. This is the twisted logic of a slave master. The master claims his oppression serves the slave's interests, while it's the master's interests that are truly being served. What this book establishes. This book is organized into 3 parts, 11 chapters, each building on a previous analysis to demonstrate the complete structure of life slavery. Chapter 1 is the disposal rights, which proves through legal analysis that the state owns your life. Whoever controls disposal rights is the true owner. You cannot dispose of your own life because you don't actually own your life. The master state owns your life. The primary breach. Parents as life enslavers identifies your parents as the original enslavers who committed the first breach by imposing existence without consent, creating an irreparable and unpayable debt. The chapter establishes the moral debt for life enslavement and the forfeiture criterion, the requirements parents must meet to provide partial restitution for the irreparable harm they cause, competent parenting, respect for autonomy, including exit rights, mandatory inheritance of at least 50% of their estate, forced heirship, and the forfeiture of their own exit rights until these obligations are fulfilled or waived by their offspring. Chapter 3, the master state as enforcer and profiteer demonstrates how the state compounds your parents' breach by using violence to deny the right to exit while extracting value through taxation, forced labor, and services. This chapter establishes the impossible choice. The state must either recognize your ineligible right to exit peacefully or provide comprehensive material support if it forces your continuation. This is my argument for socialism for those who are interested in that. If the state refuses both options, leaving you to bear the cost of your own enslavement, it exposes its own illegitimacy. The judiciary role in legitimizing life slavery documents how courts systematically decline to provide legal redress through immunity doctrines, qualified immunity, prosecutorial immunity, sovereign immunity, and judicial immunity, procedural barriers, summary judgment, standing, mootness, political question doctrine, and the legal profession's monopoly over the practice of law. Courts provide a performative forum that offers false hope of being heard, but is ultimately predetermined to legitimize the violence that maintains the system of life slavery. Chapter 5, State Control over Disposal Rights, proves enslavement examines how the law operates as an enforcement mechanism of life slavery. This chapter reveals that every law is violence-backed by the state's monopoly on the use of physical force, that legitimacy is manufactured through systemic programming rather than genuine consent, and that the state controls disposal rights through 3 domains: person, property, and services, satisfying the Supreme Court's own definition of slavery in Plessy versus Ferguson. Chapter 6, Perpetual Violence. The enforcement mechanism of life slavery catalogs the comprehensive perpetual violence the master state deploys to maintain life slavery. Involuntary psychiatric commitment, property seizures through taxation and asset forfeiture, forced labor through occupational licensing restrictions, compulsory jury service, and traffic citations given while commuting to your place of employment to maintain a life that you don't even own. This chapter documents the contradictory messages. Pull yourself up by your bootstraps when you need help. You are not alone when you seek the right to exit, and examines the walking dead, those who have nothing left to lose after prolonged exposure to the comprehensive injustice of life slavery. Capitalism. The economic pillar of life slavery demonstrates that capitalism depends fundamentally on state violence to function. Property rights are violence-backed fictions enforced through police, courts, and prisons. Work or starve is coercion when state violence maintains artificial scarcity through occupational licensing, intellectual property, and deliberate creation of homelessness to extract rent. Capitalism extracts surplus value through wage slavery, which as a pillar of life slavery operates through the exploitation of your labor, given the alternative is starvation. Chapter 8, The Public's Complicity. Democratic authorization of comprehensive violence demonstrates why democracy cannot remedy life slavery when participation is coerced and the majority benefits from life slavery. This chapter establishes 5 independent grounds for public liability: public agent relationship, unjust enrichment, creation of peril, control-based duty, and special relationship duty. Democratic participation in a system that prohibits the right to exit makes participants complicit in maintaining enslavement. They must either support exit rights or provide full material support for those whom they enslave. The Life Slave Ledger is Chapter 9. The complete accounting provides the complete, Chapter 9 provides the complete accounting. You bear over 5.9 million in measurable expenses, physical maintenance costs, sleep, food, housing, medical care, clothing, transportation, economic costs, 101,250 hours spent, 627,000 in taxes, 2.7 million in surplus value extracted by capitalists, psychological costs, existential distress, emotional suffering, mental illness risk, moral injury, temporal costs. 54% of your life is consumed by mandatory activities, social costs, forced relationships, forced performance, ostracism for noncompliance, systemic costs, perpetual state violence, rights without rights without remedies, identity costs, burdens imposed without consent, and existential costs, meaninglessness, mortality, awareness, suffering without purpose. You receive no remuneration from your parents, the state, or society. The debt is irreparable. The ledger is clear. You got screwed. Chapter 9, Procuration as the root cause of life slavery, demonstrates that your parents' decision to create you is where the chain of enslavement began. This chapter establishes the asymmetry between existence and non-existence. You cannot benefit from being brought into existence. You are always harmed by being brought into existence. The consent problem. Procreation imposes costs without the possibility of consent. The risk imposition problem. Procreation is reckless endangerment, and the unjust enrichment solution to the non-identity problem. As you know, a lot of people have they purported to debunk antinatalism by saying that you can't be harmed by being brought into existence because you would have to exist in order to be harmed. I have already resolved the non-entity problem because my framework is not based on the fact that you're harmed by being brought into existence. It's that that was the initial breach, but you're harmed by the fact that you exist, and everybody else, the state, the master state society, your interpersonal relationships are based on extraction. It is to your detriment. You do not benefit from it at all. So it's based on unjust enrichment. It's not based on the fact that you were harmed by being brought into existence. It's based on the fact that you're here now providing benefits to society without any remuneration. Where was I? And the unjust enrichment solution to non-entity problem. Parents are enriched at your expense under circumstances making retention unjust, regardless of metaphysical questions about whether you are wronged by being brought into existence. Every reason to procreate is selfish. Without procreation, there would be no new instances of life slavery. Chapter 9, Life Abolitionism, exposes the system's complete illegitimacy, presents the complete framework for ending both state life slavery and procreative life slavery. Life Abolitionism synthesizes four philosophical traditions: anti-natalism, pro-mortalism, anarchism, and socialism into a unified political strategy operating across five fronts: legislative action, judicial challenges, civil disobedience, asylum claims, and cultural transformation. The framework explains why academic anti-natalism has failed. No relief for those already enslaved, no consequences for procreation, no political strategy, and forces the state into an impossible choice: either remove all peaceful exit restrictions, option one, or provide comprehensive material support for forced continuation, option two. Life abolitionism creates voluntary accountability mechanisms that eliminate the guaranteed return on investments parents receive from procreation, making continuation of life slavery more costly than its abolition, while demanding immediate recognition of exit rights for those already enslaved. Um, what makes this argument different? Philosophers have argued that procreation is ethically problematic. David Benatar's Better Never to Have Been establishes the asymmetry between existence and non-existence. Anti-natalist philosophy recognizes that imposing existence without cause causes harm, but anti-natalism alone is insufficient. Anti-natalism identifies the harm of being brought into existence, but provides no remedy for those already existing, no consequences for those who procreate, and no political strategy for change. Anti-natalism remains academic, a philosophical position disconnected from material conditions and political power. Anarchists have argued that the state's monopoly on violence is illegitimate. They recognize that every law is ultimately backed through violence, that manufactured consent creates the illusion of legitimacy, and that no one genuinely consents to state authority merely by being born within clean borders. But anarchism alone is insufficient. Anarchism opposes state violence, but often fails to recognize that the prohibition on the right to a humane exit is among the most fundamental exercises of illegitimate state violence. Many anarchists focus on economic arrangements or police brutality while ignoring that the state claims ownership over our very existence. Socialists have argued that capitalism extracts surplus value through coercion. They recognize that the work or starve predicament is not a voluntary exchange when state violence maintains artificial scarcity and enforces property claims divorced from productive use. But socialism alone is insufficient. Socialism addresses economic exploitation, but often accepts state forced continuation of existence, treating the prohibition of the right to exit as a legitimate state interest in preserving life rather than recognizing it as enslavement. Pro-mortalists have argued that death is not inherently harmful and that preventing a peaceful exit causes unnecessary suffering. They recognize that state forced continuation serves the interests of those who benefit from your captivity rather than your own interests. But pro-mortalism alone is insufficient. Pro-mortalism addresses the harm of prohibiting one's exit, but fails to identify who created the predicament in the first place: your parents who imposed existence without consent, creating an irreparable harm and an unpayable debt. This book synthesizes all four traditions into a unified framework: from anti-natalism, the recognition that procreation imposes existence without consent, creating an irreparable harm; from pro-mortalism, the recognition that prohibiting one's exit compounds the original harm and forces the continuation of irreparable suffering; from anarchism, the recognition that state violence maintaining this arrangement is illegitimate; from socialism, the recognition that if the state forces continuation, it must provide full material support as partial restitution for the irreparable harm it perpetuates. The synthesis reveals what each tradition alone cannot. You are enslaved by two distinct parties through two distinct breaches, requiring two different forms of restitution. Your parents enslaved you by imposing existence without consent, creating an irreparable harm they can never fully remedy. The state enslaves you by prohibiting your exit while extracting value, compounding an irreparable harm while refusing to provide even partial restitution. Both must be held accountable. Both must provide whatever restitution is possible, even though full restitution is impossible. This is not merely philosophy, this is a framework for political resistance. Who is this book for? This book is for anyone who recognizes that something is fundamentally wrong with the arrangement into which you were forced. You did not choose to exist, yet you bear all the costs of your existence. You cannot exit humanely, yet the state extracts value from your forced continuation. You are told you should be grateful for the gift of life, yet no one asks whether you wanted this gift or provided restitution for its comprehensive and irreparable cost. If you've ever wondered why you must participate in a system for which you never consented, this book is for you. If you've ever been told if you don't like it, you should just kill yourself, only to discover that the right to a humane exit is prohibited, this book is for you. If you ever calculated the cost you bear and realized you receive nothing in return, this book is for you. If you've ever been labeled mentally ill for recognizing that state forced continuation of your involuntary existence is oppression rather than benevolence, this book is for you. If you ever sought redress through courts only to discover that immunity doctrines, procedural barriers, and a legal profession's monopoly prevent access to justice, this book is for you. If you ever voted for change only to discover that democracy serves the majority who benefit from life slavery rather than those who bear its cost, this book is for you. If you're a parent who recognizes that procreation imposed irreparable costs without consent and wants to understand what restitution you morally owe, this book is for you. If you're considering procreation and want to understand the full implications of that decision, the irreparable harm you will inflict, and the unpayable debt you will incur, this book is for you. If you are an activist seeking a framework for challenging the systemic violence that maintains life slavery, this book is for you. This book provides the analytical tools, the legal framework, the economic analysis, the complete accounting, and the strategic vision necessary to understand life slavery and to demand its abolition. A note on tone: this book is confrontational by design. You have been enslaved for your entire life. Your parents forced you into existence without consent, inflicting irreparable harm and creating an unpayable debt. The state prohibits you from leaving while extracting value from your forced continuation, compounding the irreparable harm while refusing to provide even partial restitution. Courts deny relief. Democracy serves those who benefit from your enslavement rather than you. Polite language would be inappropriate. Euphemism would serve power. Academic detachment would betray those suffering under comprehensive violence. This book calls slavery slavery. It calls forced continuation enslavement. It identifies your parents as life enslavers and the state as the master state. It acknowledges that the harm is irreparable and the debt unpayable, yet insists on restitution. The language is precise, not hyperbolic. Some readers will some readers will object to the tone. They will say the argument would be more persuasive if presented academically, that harsh language alienates potential allies, and that political change requires building coalitions through moderate rhetoric. This objection misunderstands this project. The goal is not to persuade enslavers to relinquish power voluntarily. The goal is to expose the system's complete illegitimacy so comprehensively that maintaining it becomes too costly. The goal is to provide analytical tools and a strategic framework for those who already acknowledge that something is wrong but lack the language and structure to articulate it. The confrontational tone makes it clear. This is not a request. This is a demand backed by a rigorous analysis of why the existing arrangement is indefensible. The harm is irreparable, the debt is unpayable, but restitution is still owed. The system must choose, permit the right to exit, or provide restitution for forced continuation. Anything else is slavery, and slavery requires abolition. I'm not going to. Okay. This book will prove that you are enslaved. It will identify the responsible parties, demand specific restitution, explain why reform through existing channels cannot be achieved, strategic actions. Some people will read this book and do nothing. They will acknowledge the argument is sound, recognize the harm is irreparable, and the debt is unpayable, but continue participating in systems that enslave them because resistance seems futile or costly. Some will read this book and begin refusing cooperation. They will stop voting in elections that legitimize enslavement, stop procreating, stop celebrating others' procreation, and stop pretending that democracy is legitimate. Some will read this book and begin active resistance. They will demand legislative recognition of exit rights and file constitutional challenges, provide mutual aid, seek asylum in jurisdiction recognizing medical assistance in dying, transform culture, and demand restitution for those who benefit from their enslavement. The framework is complete, the analysis is rigorous, the strategy is clear, the harm is irreparable, but restitution is still owed. The work begins now. All right, I'm not going to read the disclaimer. This book is one-sided. I'm admitting that up front. I guess I can say why this book is so one-sided. This book it does not present both sides because the other side controls the means of presentation itself. What you will encounter here is not merely an alternative viewpoint, but a perspective systematically excluded from mainstream discourse, actively censored on most platforms, and pathologized when it appears. The dominant framework is not presented here because it requires no presentation. It is the water in which we swim, the air we are forced to breathe. Those who benefit from this current arrangement may find this book to be one-sided, extreme, or unbalanced. They can afford such objections. They are not the ones being held captive. I'm not advocating for self-administered the S word. I'm not going to say. I'm just arguing for the right to safe and humane exit rights through medical procedures for those who don't want to exist. So so for those who like, I'm not trying to get my channel flagged because I'm not arguing what you think I'm arguing for. I'm arguing for a right which already exists in a few countries. If you are suicidal, need to call 988. Don't put it on me. Don't say that you did it because of my book, because I am not advocating that. It is not my responsibility. You need to think for yourself. But understand that mental health interventions often function to institutionalize and pathologize victims rather than respecting autonomous decision making regarding one's own existence. Moreover, crisis intervention models are designed to address acute psychological distress, are ill-equipped to engage with profound existential inquiries concerning the fundamental value or justification of existence itself. Such philosophical questions about the meaning, purpose, or desirability of life transcend the clinical framework of crisis management, which presupposes that continued existence is always preferable. The only guaranteed way to eliminate suicide and death in general is to not impose life onto people in the first place. I think I'm going to... Yeah, I think I already... Let's see if I have any comments before I keep going. Oh, thank you. Yeah, thank you so much for your support. All right. I guess I can keep going. I'm just going to go through chapter 1 and I'm going to stop. The introduction argues that you were enslaved, but to understand the full scope of the moral debt for life enslavement, we must first prove definitively that you do not own your life. This chapter provides that proof through the disposal rights test. You believe you own your life. Test this belief with a straightforward question. Can you dispose of it? Can you legally contract with a physician for medically assisted death? Can you exercise what property law recognizes as the ultimate incident of ownership, the right to dispose of what you possess? The Supreme Court in Plessy v. Ferguson defined slavery as slavery implies involuntary servitude, a state of bondage, the ownership of mankind as chattel or at least the control of the labor and services of one man for the benefit of another, and the absence of a legal right to the disposal of his own person, property, and services. The critical element of our analysis is the final phrase, the absence of a legal right to the disposal of his own person, property, and services. The disposal rights test applies this definition directly. If you lack the right to dispose of your own person, you meet the court's own definition of slavery. In nearly all jurisdictions worldwide, the answer is no. Either the law completely prohibits medically assisted death, or it permits access only under state-imposed criteria. Even in the world's most progressive jurisdictions, you cannot simply access medically assisted death as a matter of right. Access requires meeting state-determined conditions that place the ultimate decision in the hands of the state rather than your own. Consider the restrictions even where laws are most permissive. In Oregon, Washington, and California, you must have a terminal illness, with a prognosis of 6 months or less. In the Netherlands and Belgium, you must demonstrate an unbearable physical or psychological suffering from a serious and incurable condition, whether or not your death is imminent. In Canada, you must have a grievous and a, irremediable medical condition causing enduring suffering that you find intolerable, and currently mental health alone does not qualify, with eligibility for those suffering solely for mental health repeatedly delayed and not expected until at least 2027. Across all these jurisdictions, you must obtain physician approval, obtain often from multiple physicians. You must satisfy mandatory waiting periods. You must meet competency standards and navigate other procedural requirements. The state dictates the conditions under which you may end your life. Physicians act as gatekeepers, enforcing state-defined eligibility criteria. The final authority rests not with you, but with the state that determines whether you qualify for the disposal of your own person. This is my first chart. Figure 1.1 illustrates the test. Property ownership requires the right to dispose said property. Can you legally achieve medically assisted death without state-imposed criteria? If yes, you own your life. If not, you don't own it. And whoever prohibits disposal is the true owner. So this is the disposal rights test. This is basically, this basically sets up the entire book. The flow chart demonstrates a logical structure for determining life ownership. The test is empirically verifiable. Readers can check their own jurisdiction's laws on medically assisted death. The distinction between rights and abilities addresses the common objection that violent suicide methods somehow prove disposal rights. You can check your own jurisdictions on medically assisted death. The answer determines ownership. You cannot legally achieve medically assisted death without satisfying state-imposed criteria, terminal illness, physician approvals, waiting periods, and suffering thresholds. Then you fail a test. You do not own your life. The chart identifies a critical distinction in the bottom box. Rights is not equal to abilities. The mere fact that you have the physical ability to terminate your life through inhumane methods does not prove that you have the right to do so. The distinction matters because it exposes a common deflection. When confronted with claims that the right to die is legally prohibited, some respond, just kill yourself if you want to die. Nothing is stopping you. The suggestion to just kill yourself ignores the comprehensive system of barriers that society has deliberately constructed to make one's peaceful death as difficult and traumatic as possible. These barriers exist at every level: religious, cultural, legal, medical, and practical, creating a maze of obstacles that the same people who built them now claim proves that you don't really want to escape. Society recognizes that bringing life into the world requires comprehensive support: medical care, financial assistance, family help, social celebration, and institutional protection. But when it comes to ending that same existence, society demands that people handle this equally profound transition entirely alone, without professional guidance, community support, or cultural acknowledgement of the decision's legitimacy. This represents a stunning double standard that recognizes the complexity of creating life while treating the termination of life as a simple individual choice requiring no existence. When people casually suggest just kill yourself, they reveal their complete ignorance about what this actually entails. None of these people have actually given serious thought to the practical requirements of ending one's own life safely and effectively. If challenged to suggest a specific method, they fall silent because they have no idea what they're actually recommending. The just kill yourself response confuses rights with abilities. You may have the physical ability to take property that does not belong to you, but this ability does not constitute a right to steal. You may have the physical ability to strike another person, but this ability does not constitute a right to commit assault. Rights are legal and moral entitlements, not mere physical capabilities. Property law does not recognize ownership based on one's ability to destroy property through illegal means. Consider real property. Suppose the state prohibits you from demolishing your house, but does not physically prevent you from tearing it down. The fact that you could illegally demolish it does not prove you have disposal rights over the property. It proves the opposite. You must resort to illegal destruction because lawful disposal has been prohibited. The same principle applies to life itself. The fact that you could terminate your life through violent means does not prove you possess disposal rights. It demonstrates that a lawful disposal has been prohibited, forcing you to resort to methods that are traumatic, unreliable, and illegal in the sense that anyone who assists you may face criminal prosecution. The state's prohibition on medically assisted death is precisely what forces people toward violent methods they would not choose if humane, reliable, medically assisted methods were available as a matter of right. Additionally, violent methods impose costs that medically assisted methods do not. They traumatize the person who is put in a position to perform the act. They traumatize family members who discover the body. They traumatize first responders who must respond to the scene. They leave bodies in conditions that they leave bodies in conditions that complicate funeral arrangements and make viewing difficult or impossible. They create liability risks for property owners where the death occurs. They involve a risk of failure that can result in severe injury without death, leaving a person in a worse condition than before the attempt. These costs are externalities imposed by the state's prohibition on humane alternative. The just kill yourself response therefore fails on multiple grounds. It confuses ability with rights. It ignores the illegal methods of property destruction do not prove legal rights of disposal. It dismisses the costs imposed by forcing people towards violent methods when humane alternatives are prohibited. It is not an argument against the claim that disposal rights are restricted. It is an admission that a lawful, dignified, medically assisted disposal is prohibited, leaving only illegal and traumatic alternatives. The critical point is that the state refuses. No, excuse me. The critical point is not that the state refuses to help you dispose of your life. It is that the state actively interferes to prevent you from disposing of it yourself or from contracting with others who would assist you. This interference is the exercise of control, and control over disposal constitutes ownership. In the state of nature, absent government, nothing would prevent you from contracting with a physician or for a peaceful as it. Excuse me. Let me read that whole sentence over. In a state of nature, absent government, nothing would prevent you from contracting with a physician for a peaceful, medically assisted death. The state's prohibition is an assertion of superior authority over your person. The state claims the right to determine whether and when your life may end. This is precisely what the Supreme Court defined as the defining characteristic of slavery: the absence of the legal right to the disposal of his own property and services. The complete definition bears repeating because it establishes the legal framework for understanding ownership. I'm not going to read that again because I've already read it twice. You lack the legal right to dispose of your own person. By the Supreme Court's own definition in Plessy, this constitutes slavery. The disposal rights test measures control. Who decides whether your life continues or ends? If the answer is the state rather than you, the state exercises ownership authority over you. Ownership is fundamentally about control over disposal, the right to determine what happens to the right to determine what happens to what you own. When a state prohibits you from disposing of your life, it asserts that the state, not you, possesses the ultimate authority that comes from ownership. Let me talk about self-ownership. Before applying property principles to examine disposal rights, we must establish the foundation. Self-ownership is a natural right, not a grant from positive law. This foundation determines whether the state's prohibition on autonomous disposal violates a pre-existing right or merely declines to create a privilege. Natural law philosophy, particularly in the Lockean tradition, provides the theoretical framework. John Locke argued that individuals possess natural rights to life, liberty, and property that exists before and independent of government. The state does not create these rights, but merely enumerates them. The state's legitimate function is to protect these pre-political rights, not to grant or revoke them at will. Locke expressly addressed self-ownership in the Second Treatise of Government. He wrote that every man has a property in his own person. This nobody has any right but to himself. This principle of self-ownership forms the foundation of Locke's entire political philosophy. From self-ownership flow the right to acquire property through labor, the right to liberty in disposing of one's person and possessions, and the limit on legitimate governmental authority. Critically, Locke used property in a broad sense that encompasses all three categories that courts now arbitrarily separate. He explained that individuals form governments for the mutual preservation of their lives, liberties, and estates, which I call by the general name property. This formulation is essential. By encompassing lives, liberties, and estates under the single term property, Locke demonstrated that property is not merely one right among others, but the comprehensive category that contains them all. The right to life, the right to liberty, and the right to material possessions are all species of property rights. Property in one's person is the foundation from which property in external things derives. When individuals form political societies, they do so primarily to protect this broad conception of property from which their ability to preserve themselves, exercise freedom, and acquire material goods all flow. In Locke's state of nature, individuals possess complete autonomy over their own persons. Government arises through voluntary consent to protect natural rights more effectively than individuals could protect them alone, but the government authority extends only as far as individuals have the natural authority to delegate. Individuals in a state of nature possess complete self-ownership, including disposal rights over their own persons. They could not have possibly delegated to the state any authority they did not possess themselves. This creates a logical problem for state prohibition on disposal rights. If individuals naturally possess disposal rights over their own persons, and if government derives its authority only from the voluntary delegation of individual rights, then government cannot legitimately prohibit what individuals themselves have the natural right to do. The state cannot exercise an authority that was never delegated to it. While Locke believed that man has a duty to preserve himself, this duty is owed to God, not to the state. Locke wrote, "For men being all the workmanship of one omnipotent, omnipotent and infinitely wise maker, they are his property, whose workmanship they are, made to last during his, not another's pleasure." Under Locke's framework, you may owe a duty to preserve yourself to your creator, but you owe no such duty to other men or to the state they created. This theological foundation actually strengthens rather than weakens the argument against state prohibition. Even if we accept Locke's premise that life ultimately belongs to God, this makes the state's claim even more problematic. The state would be asserting an authority that belongs properly to God alone. The state would be claiming divine prerogatives without divine authority. Secular readers can simply reject the theological premise entirely and retain the conclusion: you owe no duty to preserve yourself for the benefit of others or for the benefit of the state. The natural law foundation explains why the Chart's test question, can you dispose of it, is the right question. Disposal rights are not merely one incident of ownership among many. They create the ultimate expression of ownership authority. To prohibit the disposal is to claim superior ownership authority. When a state prohibits you from disposing of your own person, it claims an authority that in natural law belongs to you, either you or God, but certainly not to the collective exercising power through the state. Some may argue that certain rights, including the right to life, are inalienable and therefore cannot be disposed of even the rights holder. The Declaration of Independence speaks of certain unalienable rights, including life, liberty, and the pursuit of happiness. But this argument confuses two distinct concepts. To say something is inalienable means it cannot be transferred to another party. You cannot sell yourself into slavery because that would alienate your liberty. You cannot contract away fundamental rights permanently because that would alienate what must necessarily remain yours. But inalienability prevents transfer to others. It does not prevent disposal. Consider an analogy. Suppose you possess an heirloom that family tradition declares inalienable, that you cannot sell or give it away, but you remain its possessor. Does this inalienability mean you cannot destroy it? That would be a separate restriction, not inherent in inalienability itself. Inalienability prevents transfer. Disposal rights concern destruction or termination, not transfer. Applied to life, the inalienability of the right to life means you cannot sell yourself into slavery or transfer ownership of your person to another. It does not mean you cannot terminate your existence. These are different acts with different moral and legal implications. The prohibition of selling yourself into slavery protects your autonomy by preventing you from permanently alienating your liberty. But prohibiting you from terminating your existence restricts your autonomy by forcing you to continue existing against your will. The inalienability argument therefore fails. Inalienability prevents the transfer of rights to others. It does not require the forced continuation of existence. If anything, the inalienability of self-ownership strengthens the arguments for disposal rights because you cannot transfer ownership of yourself to another, including the state. You must retain ultimate authority over your own person, including the authority to determine when your existence ends. Let's see how long this is. Okay, I don't. Let me. The distinction between natural rights and positive law becomes critical here. Natural rights exist independent of government recognition, statutes, or constitutions do not create them. They are discovered through reason and inherent like persons as autonomous moral agents. Positive law can recognize and protect natural rights, or it can violate them. When positive law prohibits the disposal of one's own person, it violates the natural right of self-ownership. The violation does not eliminate the natural right. It merely demonstrates that positive law operates contrary to natural law. The Ninth Amendment to the Constitution explicitly recognizes this possibility. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This amendment acknowledges that rights exist beyond those specifically enumerated. Those unenumerated rights, natural rights not explicitly listed, remain valid whether or not positive law recognizes them. Self-ownership qualifies as such a natural right. Even though the Constitution does not explicitly enumerate the right to dispose one's own person, this right exists as a logical implication of self-ownership. The Ninth Amendment's framers understood that attempting to enumerate all natural rights would be impossible and dangerous. Impossible because natural rights are potentially infinite. Dangerous because enumeration might suggest that unenumerated rights do not exist. Okay, I'm going to skip that. I'm not going to read the entire chapter. Where I really okay, I'll read Rousseau, then I'm going to get to the burden of proof. Um, Jean-Jacques Rousseau offers an alternative framework that explicitly rejects natural rights and self-ownership. In a social contract, Rousseau argues that individuals in civil society have no pre-political rights that the state must honor. Instead, Rousseau postulated that all rights are created by the social contract itself. When individuals enter the state of society, they completely alienate all natural liberty and submit entirely to the general will. The general will then grants civil liberties and property rights, but only those rights the general will chooses to grant. Under Rousseau's framework, the question, whose life is it, receives a different answer. It belongs to the sovereign, which is the collective body of citizens expressing the general will. You possess your life only as a conditional grant from the sovereign, revocable when the sovereign revocable when a sovereign determines your continuation no longer serves the common good. This framework is more honest than liberal frameworks that claim to respect individual rights while prohibiting disposal rights. Rousseau explicitly acknowledged that the state owns citizens and that citizens possess only those liberties the state grants. There is no pretense about natural rights that governments must respect. There is only the general will and its determination. However, Rousseau's framework reveals why modern democratic states operate as masters. If your rights are merely granted from the collective will, and if the collective will determines that you shall continue existing whether you consent or not, then you are subject to the collective's authority in the most fundamental possible way. You are property of the collective. This is slavery, even if we call the master the general will, rather than the master. And even if we say the collective owns you rather than an individual master. Rousseau promised reciprocity, that you get equivalent rights over others in exchange for giving up rights over yourself, proves hollow when the rights you receive are determined by a majority rule. If the majority decides that your continued forced existence serves their interests, your participation in the general will that enslaves you provides no consolation. You become both a slave and a fractional master. But the slavery you endure is complete. At the same time, the mastery you exercise is diluted across the entire citizenry and subject to majority rule, which may not align with your interests. All right, I'll read Gluckberg and then I'm going to talk about the burden of proof. In Washington versus Gluckberg, the Supreme Court held that there is no fundamental liberty interest in assisted suicide and declined to recognize such a right under the 14th Amendment. Courts analyzing end of life decisions typically frame them as liberty interests subject to state regulation rather than property interests that might receive stronger protection. Modern courts distinguish between liberty and property interests under the 14th Amendment's due process clause. This distinction is artificial and contradicts the natural rights framework from which these constitutional protections derive. Under current Supreme Court doctrine, the due process clause protects both liberty and property, but courts treat these as separate categories with different levels of protection. Property interests receive stronger protection. The government cannot take property without just compensation under the Fifth Amendment's takings clause. Liberty interests receive judicial scrutiny, but can be restricted when the state demonstrates a sufficient state interest. This separation makes no sense within Locke's framework. As demonstrated above, Locke explicitly defined property to include lives, liberties, and estates. These are not three separate categories of rights. They are three manifestations of the single comprehensive right of property in oneself. When Locke wrote of property, he meant the entire bundle: your person, your freedom, and your possessions. The framers understood this. The Fifth Amendment due process clause states, no person shall be deprived of life, liberty, or property without due process of law. The structure of this clause, placing life, liberty, and property in parallel, reflects Locke's framework, where all three are species of property rights, deserving equivalent protection. But modern courts have abandoned this unified framework. They treat liberty interests and bodily autonomy as subject to state regulation for the public good, while treating property interests and physical possessions as requiring compensation when taken. This creates a perverse result that the state may take your life for a public purpose, e.g., interfering with disposal rights of your person, by forcing you to continue existing without providing any compensation, but is not permitted to seize your house without paying you fair market value. The court's refusal to recognize life as a property interest, therefore represents a doctrinal choice to weaken protection for the right to self-ownership. By separating life from liberty, courts enable the state to regulate the former more extensively than the latter. If courts instead recognize that life, liberty, and estate are all forms of property under Locke's framework, the framework that underlies the Constitution, then the state prohibition on disposal rights would constitute a taking requiring compensation or would be prohibited entirely as an uncompensated regulatory taking of property. Okay, this is the important part. Courts consider historical parallels. Southern courts refused to recognize that enslaved persons had a natural right to liberty or self-ownership. Courts enforced laws treating humans as property belonging to masters. The court's refusal to acknowledge these persons' natural rights did not mean the rights did not exist. It meant the legal system operated in violation of natural rights. When courts abandoned natural law in favor of substantive due process as the framework for unenumerated rights, they created a system in which rights exist only to the extent that courts deem them deeply rooted in a nation's history and traditions. This standard allows courts to refuse protection for natural rights that positive law has historically recognized. If the right has been traditionally denied, courts conclude it is not protected, creating a circular justification for continued historical violation. Natural law trumps positive law. To the extent that positive law conflicts with natural rights, positive law operates ultra vires. Courts' refusal to recognize life as property and the refusal to protect disposal rights therefore prove that the legal system operates unlawfully. This is the foundation for understanding the argument. You possess a natural right to dispose of your person. Positive law violates this right, and this violation constitutes slavery. Positive law provides the analytical framework for understanding why the state's interference with disposal rights proves state ownership. This framework has been extensively developed over centuries of common law and refined by legal scholars who have systematically examined what property ownership means. A.M. on Henry's classic analysis identify 11 incidents of ownership, the fundamental rights that constitute property ownership. These include the right to possess, the right to use, the right to manage, the right to income, the right to capital, which includes the right to destroy or consume, the right to security, the right to transmit, the absence of the term, the prohibition of harmful use, liability to execution, residuary rules. Among these incidents, Henry emphasized that the right to capital is particularly significant. This right includes the right to consume, waste, modify, or destroy that property. It is precisely this incident that the disposal rights examines when applied to self-ownership. American property law so vigorously protects disposal rights that the restatement third of property states servitudes that lack a rational justification or that are arbitrary and impose a substantial cost on the burdened estate are invalid as unreasonable. A servitude that completely prohibits an owner from destroying property lacks rational justification because it eliminates a fundamental incident of ownership. The Supreme Court has recognized that regulations that eliminate fundamental ownership interests constitute regulatory takings requiring compensation. In Pennsylvania Cole versus Mahan, Justice Holmes wrote that while property may be regulated to a certain extent, if regulation goes too far, it will be recognized as a taking. In Cedar Point Nursery versus Hasid, the court held that regulation that deprive property owners of even limited access to their property constitute per se takings. If eliminating the right to destroy physical property goes too far and constitutes a taking, then eliminating disposal over one's own person represents an even more fundamental deprivation. When a state prohibits you from disposing of your own person, it does not merely regulate ownership, it appropriates ownership authority entirely. This property theory provides a foundation for why the chart's test is valid. The chart asks whether you can dispose of your life, whether you possess the ultimate incident of ownership. Property law recognizes that without disposal rights, ownership is illusory. An owner who cannot determine whether property continues to exist or ceases to exist lacks ownership authority. The state interferes with disposal rights. With disposal exercises authority over the state that interferes with disposal exercises ownership authority that the possessor lacks. The political equivalent of disposal rights is the right to opt out. And property, by the way, the right to opt out is a term that John Locke used explicitly. In property law, disposal means determining whether the property continues to exist or ceases to exist. In political relationships, opting out means deciding whether to continue or withdraw from the political system. Albert Hirschman identified three responses to available to members of organizations: exit, voice, and loyalty. Exit means leaving, voice means staying and attempting to change the organization. Loyalty means staying and accepting things as they are. Hirschman argued that effective organizations allow exit as a discipline mechanism. When members can leave, the organization faces incentives to be responsive to their concerns. Applied to the state, the right to exit means the right to opt out of political obligation. Voice means political participation, voting, advocacy, protest. Loyalty means accepting the system as it is. A legitimate political order must allow an exit. Without the right to exit, voice becomes meaningless because the system lacks a disciplinary mechanism. Citizens cannot threaten to leave if their concerns are not addressed. So the system has a reduced incentive to be responsive. Participation becomes coerced rather than voluntary because staying is mandatory regardless of whether participation produces acceptable outcomes. The right to opt out of existence is the ultimate exit. It is the meta-exit that renders all other forms of coercion tolerable. If conditions become sufficiently intolerable, you should be able to exit entirely. But the state prohibits this meta-exit. It renders every other form of coercion absolute. You cannot escape through death, so whatever suffering the system imposes becomes inescapable. The state's prohibition on opting out is therefore the foundation of its absolute authority. It has eliminated the last constraint on its power over you. David Hume recognized this principle when he wrote, "A man who retires from life does no harm to society. He only ceases to do good. The state's interference with one's autonomous disposal cannot be justified by preventing harm to society because using death harms no one. It merely withdraws one's continued contribution. The only harm such a choice could possibly inflict is the cessation of what can be extracted from the person and the affront to state authority itself. The state's interference with personal sovereignty to ensure continued extraction and to assert its fundamental claim. I own you. Who are you to decide where you want to leave? The state that prohibits this escape reveals its true concern, not protecting the individual, but preserving its domination over you. By denying you this choice, the state declares you exist for its purposes, not your own, that you may not escape even when your life no longer benefits you, even when you get nothing from your continued existence. I'm going to skip this part of it. Some may argue that jurisdictions that permit aid in dying under restricted circumstances disprove the claim that disposal rights are prohibited. If Oregon allows aid in dying for terminal illness, doesn't this prove that individuals can dispose of their life? This objection misunderstands the disposal rights test. The question is not whether the state ever permits disposal, but whether you possess disposal rights as a matter of ownership or merely as a matter of state permission. An owner does not require permission to dispose of what they own. A possessor who must obtain permission from another to dispose proves that by that very requirement, they are not the true owner. Consider private properties. Suppose the government prohibits you from destroying your laptop without obtaining permission. You can apply for a destruction permit if you satisfy all requirements, show that the laptop contains sensitive data, requiring secure disposal, get approval from your IT department, pay fees, wait mandatory periods, you may receive permission to destroy it. Does this permission prove that you own your laptop? No, it proves the opposite. The requirement that you obtain permission demonstrates that you lack disposal rights. An owner would not require permission from the government to destroy what they own. The fact that permission is sometimes granted after satisfying state-imposed criteria proves that disposal is controlled by the state, not by you. The same analysis applies to your life. If you must prove to physicians that you have a terminal illness, satisfy waiting periods, meet competency standards, and obtain approval before you may end your life, then you lack disposal rights. The state exercises ownership authority by determining the conditions under which disposal may be permitted. You are not exercising a right. You are requiring permission, and permission is what possessors require from owners, not what owners exercise over their own authority. The disposal rights test, as illustrated in Figure 1.1, answers the question, whose life is it, with stark clarity. It is whoever controls disposal. When a state retains authority to grant or deny permission for disposal, when physicians act as gatekeepers enforcing state-determined eligibility criteria, the state owns your life. You are a possessor, not an owner. The state is the owner who determines when, whether, and under what conditions disposal may occur. Now, this is the most important part of this chapter, beside the actual disposal right test. The predicted objection to this analysis is that it assumes that the state owns person. This objection itself commits the logical fallacy it claims to identify. The problem is not that this analysis assumes state ownership. The problem is that objectors assume self-ownership without evidence. The disposal rights test makes no initial assumption about who owns your life. It begins from a neutral baseline. Ownership is determined by control over disposal. This is not an ideological position. This is how property law defines ownership. The test asks an empirical question: who actually controls disposal of your person? The question is observable and verifiable. You cannot legally dispose of your own person through medically assisted death without state imposed criteria. The state criminalizes assistance with your own autonomous disposal. The state forcibly commits you if you attempt disposal autonomously. These are not disputable facts. This is the actual legal framework under which we exist. The conclusion the conclusion follows from observed control, not from assumption. The reasoning operates through a simple syllogism. Premise one: ownership requires control over disposal. Property law principle. Premise two: you lack control over the disposal of your person. Conclusion: therefore, you do not own your life. This negative claim is established. Ownership authority must reside somewhere. It cannot simply vanish or remain ownerless. The state exercises final control over disposal of your person. The burden now shifts to objectors. They must prove either that ownership can exist without an owner, or that ownership resides somewhere other than with the entity exercising actual control over the disposal. This methodology exposes the burden shifting tactic objectors deploy. When they demand proof the state owns you, they are committing the fallacy of begging the question, attempting to preserve an unexamined premise, self-ownership, by demanding proof of its negation. But self-ownership was never established. It was simply assumed. The disposal right test rejects this assumption and assumes property principles neutrally. The test proves you do not own your life. Objectors must then explain where ownership resides if it's not with the state. The state's control over the disposal of your person satisfies a critical element of the Supreme Court's own definition of slavery: the absence of the legal right to the disposal of its own property and services. Chapter 5 will demonstrate that the state's control extends to all three domains: person, property, and services, completing the Plessy framework. Those who object to this conclusion bear the burden of explaining how ownership can exist without control over disposal, or identifying where else ownership authority resides. Property law provides no mechanism for ownerless ownership. Ownership without disposal is possession, not ownership. The state permits the conditional use of your life, but retains ultimate ownership authority through its monopoly over disposal. The predicted objection to this analysis is that it assumes the state owns person. I guess I thought I corrected this. I'm sorry, y'all. I repeated that twice. I need to go back and correct that. I think I'm going to end this here. Just that the court made a distinction between the right to refuse medical assistance and the right to terminate your life. It's an arbitrary distinction because both are based on bodily autonomy. Both are based on battery. And so what I'm arguing is that the imposition of life was the original battery. So by denying you the right to terminate your life, the state is actually perpetuating the original battery. I mean, you guys can read it because I explained it in detail. But I think I'm going to conclude this. I need to go back and fix that because I did state the whole premise twice. I thought I had already deleted it. Do we have any comments here? All right. Well, hi everybody. So yeah, I need to make one final update on this book because I thought I took that out, but apparently I did not. So you will have an updated version before the end of the day. So for those of you who have already downloaded it, you probably should download it again because I need to make a correction. All right, y'all. Have a good day, and I will come back to review more of this book.